This Supreme Court decision dealt with the Pledge of Allegiance and the use of the American flag in schools. The court struck down a state resolution that allowed schools to expel students who refused to stand for the Pledge of Allegiance on the basis that refusing to stand constituted an act of insubordination. The court decided that forcing students to stand for the Pledge of Allegiance violated their freedom of speech and their freedom of religion. This case determined that the right to not speak is as equally protected under the First Amendment of the United States Constitution as the right to free speech. Let's look at the background in 1940s America. Mandatory flag pledges in public schools were motivated by a patriotic fervor in wartime America. There were pre-war concerns about citizens displaying national loyalty. In 1940, the Supreme Court voted 8-1 that a Jehovah's Witness child could be expelled from a public school in Minersville, Pennsylvania, for refusing to salute the flag on religious grounds. This case was Minersville School District versus Gobbidis. As the United States of America moved closer to entering World War II, Jehovah's Witnesses endured increasing harassment for being un-American. Gobbidis had the unintended consequence of fueling hatred against witnesses, as citizens misinterpreted the court decision to mean that witnesses were traitors to the country. Attacks on Jehovah's Witnesses increased. Students were teased, bullied, and assaulted by their peers. Adults boycotted businesses owned by Jehovah's Witnesses. Places of worship were burned down. Jehovah's Witnesses were jailed, brutally beaten, tarred and feathered, run out of town, and in some cases, castrated or lynched. First Lady Eleanor Roosevelt tried to appeal for calm and for the violence to stop. Critics of the Gobbidis decision became more vocal as violent acts increased. Even Justices Black, Douglas, and Murphy, who had originally supported Gobbidis, changed their minds and believed the case had been wrongly decided. Justice Murphy started looking for an opportunity to revisit the case. It would come 3 years later in the form of West Virginia State Board versus Barnette. What was going on in West Virginia? In 1941, the West Virginia State Board of Education adopted a rule that forced all teachers and students to recite the Pledge of Allegiance at the start of the day. If a teacher refused, it was grounds for dismissal. Readmission would be denied until they agreed to comply. If the student refused, he would be found insubordinate and would be expelled from school. He would not be readmitted to school until he agreed to recite the pledge. Meanwhile, he was considered to be unlawfully absent and subject to delinquency hearings. If found guilty, the student's parents could be fined $50 per day with up to 30 days in jail. Groups including the Parent and Teachers Association, the Boys and Girl Scouts, the Red Cross, and the Federation Women's Clubs complained that the flag salute used at the time with a stiff arm and palm down was too much like Hitler's Sieg Heil and received modifications to the salute. The modifications allowed them to use the Bellamy salute with palm up instead. The Bellamy salute was later replaced by the hand-over-heart salute for civilians when Congress amended the Flag Code on December 22, 1942. There were no modifications or exceptions made for Jehovah's Witness students who complained. Their religious beliefs included a literal version of Exodus, chapter 20, verses 4 and 5, which says, "Thou shalt not make unto thee any graven image, or any likeness of anything that is in heaven above, or that is in the earth beneath, or that is in the water under the earth. Thou shalt not bow down thyself to them, nor serve them." They considered that the flag was a graven image and refused to salute it. 9-year-old Gathy and 8-year-old Marie Barnette were Jehovah's Witnesses who attended Slip Hill Grade School near Charleston, West Virginia. Their father, Walter Barnette, would not allow them to salute the flag. He believed that participating in this school ritual would violate the religion's belief that the only thing to be worshipped was God. Their teacher was understanding, but the principal was not. He sent them home and expelled them for noncompliance. Here are the results of the court rulings. Walter Barnette and a few other witnesses sued the West Virginia State Board of Education in federal court. They claimed that their children's First Amendment rights were violated by this compulsory flag salute. This case was Barnette versus West Virginia State Board. A clerk error misspelled Barnette as Barnett with a silent E at the end in the case. At the time, they faced a difficult legal obstacle: the Supreme Court's previous decision in Minersville School District versus Gopatis. Surprisingly, the federal court judges ruled in favor of the children in Barnette versus West Virginia State Board of Education on October 1942. Judge John Parker said that the panel did not feel obligated to follow Gopatis. Kathy and Marie were allowed back in school. The school board was not happy with the decision. In West Virginia State Board versus Barnette, it appealed to the Supreme Court. They were confident that the Supreme Court would reaffirm its ruling in Gopatis. Instead, the Supreme Court also ruled in favor of Barnette and voted 6-3 to reverse Gopatis. On Flag Day, June 14, 1943, it ruled that a mandatory flag salute and a Pledge of Allegiance violated First and 14th Amendment rights. This case has left a lasting legacy. This famous definitive case firmly established that public school students had First Amendment rights and that the First Amendment often prohibits the government from compelling people to engage in certain speech. Trying to achieve patriotism and national unity among the students through a mandatory salute and pledge was not a justified reason for the Board of Education to deny the students their right to practice their religion. Their practice of remaining silent was not harming anyone around them. The practice of the board and the schools trying to enforce this unfair mandatory pledge requirement was harming the students and their families. Justice Robert H. Jackson wrote for the majority opinion of the court. He emphasized the rights of minorities against the tyranny of the majority. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. This case protected and expanded First Amendment rights not just for Kathy and Marie Barnette, but for all of us.